to Legally Speaking, with me, Tarun Nangia. Today, we are going to discuss a subject which will be very interesting from the education point of view and also from the point of view of administering justice. The point is dispute resolution mechanism, continuing legal education for judges. And because these days, it's not uncommon to hear that what would be the punishment for a crime which is committed in the metaverse, which could have a lot of implications. There is currently no law on this issue, but there are many other issues that needs to be tackled with as crime, in a sense, changes its forms. And today we're going to discuss that in detail. I want to welcome a very special panel today. First of all, let me welcome Justice Arjun Kumar Sikri. Justice Sikri, as you know, has served as Judge Supreme Court of India, currently also serving as International Judge of Singapore International Commercial Court, and a very well-known arbitrator from India. May I welcome Professor Raj Kumar. He is the founding Chancellor of the O.P. Jindal Global University.
Vice Chancellor.
Founding, may I correct myself, is the founding Vice Chancellor of the O.P. Jindal Global University. But more than that, he is credited with changing the face of how legal education is imparted in this country and putting India's name on the global map as far as legal education is concerned. Welcome, Professor Kumar. I would like to welcome three guests who are joining, who are currently in India, but serve as judges at the Hawaii Supreme Court in the United States of America. May I welcome Justice Todd Edens, Justice Sabrina McKenna, and Justice Michael Vincent. Justice Wilson, of course, you've earlier seen on Legally Speaking with Tarun Nangia, and we get the pleasure of seeing him once again after 3 years. First of all, let me request Professor Raj Kumar in about 2 minutes to give the opening comment before we go on to, in a sense, take the first few comments from our panelists. Professor Kumar, your opening comment.
Thank you very much, Tarun, for this discussion. I think I'm the odd man out among the 4 judges who are present here. And so, taking my academic privilege, I must say that, we have to recognize...
Sorry, I'm interrupting. When we talk of legal education, you are not an odd man out.
Thank you, sir. So, as far as the future of dispute resolution is concerned, I think all of us who are part of the broader legal system, be it representing the judiciary or the legal community, legal profession, or the legal education, we need to be mindful of that. In fact, we know for sure that when in India, approximately, we came to know that pre-pandemic, there were over 30 million cases that were pending. And we heard from the Chief Justice of India not so long ago that the post-pandemic situation is that we probably have nearly 50 million cases that are pending in Indian courts. So the question of dispute resolution, including alternative dispute resolution, emphasis on arbitration and mediation and conciliation, becomes extremely critical when it comes to the future of Indian judiciary and how disputes need to be responded to. Equally, I will say that one of the very neglected aspects of the judiciary is the fact that to what extent we are preparing our judges for new issues that are coming up beyond what their legal education might have trained. While our judges, not just in India, but around the world, are very conscious about advancing the cause of rule of law and access to justice, when it comes to new aspects of emergent areas of law, their opportunity to be exposed in those areas are relatively limited. Because they're obviously very busy in their own responding to cases and reading and preparing for trials and things like that. So there is a very deep felt need for building a robust, continuing judicial education system. India has responded to by the establishment of the National Judicial Academy and the State Judicial Academies. But I must confess, and I'm sure Justice Secretary will bear me out, that even these academies should not be places where the judges are constantly teaching judges. We need to move beyond that approach where the interaction is not only limited to judges. There should be opportunities to bring academics and people from other walks of life to have a more deeper and a more nuanced understanding of issues. So the topic and the theme of today's discussion cannot be more significant: the issue of dispute resolution and the future of judicial education.
Thank you for that opening comment, Professor Kumar. I'll go to Justice Sikri at this point. So I have seen you in the past decade or so. You, at least in India, championed the cause of mediation earlier, in arbitration too, which you yourself and also when you speak, say how it could greatly contribute to the faster disposal of cases through arbitration. And also, I remember having discussed with you complex issues involving construction arbitration, technical expertise needed for different kind of cases. Keeping all that in mind, if you could give me an opening comment on how, in a sense, continuing legal education for judges and how ADR also could keep up so that, as Professor Kumar said, about 50 million cases pending, close to 50 million. I think it's a Herculean task, at least in this country, to get this system moving up fast. Your opening comment.
Yeah, thank you, Tarun. And along with you and Rajkumar, I welcome my three distinguished and lovable guests from Hawaii. Coming to your question, I think this is very pertinent question, and this debate today in the context, and we can have some comparative analysis and narratives on this because we have judges who have rich experience in America and particularly in Hawaii, and what has been happening in India. Let me actually what Professor Rajkumar has said, I entirely echo, and let me present the same thing in a little different way from my experience. You see, what I feel is in last, apart from, the volume of cases in India, we had about 30 to 31 million cases pre-COVID, which have risen to 50 million. That is notwithstanding the fact that courts were not shut during COVID and court continued to work online. But since the court could not work in full measure and that capacity which was normally in normal times we were able to have, so it has given rise to the number of cases. Now, dispute resolution mechanism, when we talk of, and therefore the moment when we talk of so many cases, and that is the experience in America as well. In 70s or 80s, America was also struggling with arrears in those in its country, and then they came out with this mediation, what you have talked about it, and ADR mechanism. Of course, arbitration has always been a choice of lawyer, and it is here to stay, and it is here to boom and prosper. But then mediation, which has also now been introduced in India as well, it's now almost 20 years because we had provided by amendment in section inserting section 89 in the CPC way back in 2002, and India has also come a long way. But what I feel is, let us look into the matter from this angle when we talk of dispute resolution mechanism, and it is not only mediation and arbitration. I will talk briefly on some other the way landscape is changing insofar as dispute resolution mechanism is concerned. What I feel is that in last few years, first of all, my first comment that there is a deep connect between law and society, law and economics, and also over a period of time, the way bar is raising insofar as human rights of people are concerned, and the dynamics of human rights, the way they are changing. So all these three factors, maybe there may be others also, have contributed to more cases having been filed. And of course, over a period of time, when the awareness is coming, the litigants are becoming aware of their rights, etc. Naturally, in order to salvage and in order to redress their grievances, they will go to court. So these are some of the reasons because of which not only on the one hand, court cases are increasing, but on the other hand, the types of cases which are now coming before the court, that is also undergoing a change. So there is a change in the first instance in traditional litigation with new issues emerging. And if I give one example only for paucity of time, did we ever hear 10 years or 20 years ago about marital rape? Now, marital rape is an issue. It's a burning issue in India. It's pending in the Delhi High Court where judgment is reserved. It has landed in the Supreme Court as well. So therefore, in matrimonial cases or in family disputes, or dispute between husband and wife, this issue is coming. And likewise, there's so many other issues. Now, with new laws and with the advancement in technology, new types of cases are coming. We have issues on privacy. We have digital issues, cyber frauds, consumer disputes. There's a paradigm shift after we have online shopping, etc., and the kinds of consumer dispute, that is also changing. So therefore, this is another thing, that new types of cases are coming up. And then even the traditional cases earlier, which were like arbitration, I'm saying, or intellectual property disputes, etc., the dimensions of those disputes are changing. Today, we have very complex international arbitration cases, and it is not confined to only domestic arbitrations. Likewise, in respect of patents, etc., again, we have international disputes, which are again very, very complex. And investment dispute, investment treaties, bilateral investment treaties, the disputes which are rising. And all this I'm speaking because I'm doing many of these cases now from my own experience. And so even commercial cases, etc., are becoming more complex. And as I said, with the new issues which have arisen, and we have seen in past few years in India and in other countries as well, as far as human rights are concerned, which I told you, like Section 377, that issue of termination of pregnancy, issue relating to, say, euthanasia, entry of female into some temples. So all these kinds of issues of women's rights, etc., the new dimension which were not there earlier. Now, all this has impact insofar as dispute resolution is concerned, and then directly as connection with the education. On the one hand, as I said, it is volumes of cases are increasing because of this reason. Of course, there are certain matters like human rights, etc., which have to be necessarily to be gone into and to be decided by the courts. But then there are other kinds where we talk of alternate dispute resolution to lessen the burden of the court, and we talk of arbitration, we talk of mediation. And not only that, in Section 89, we have it talks of lok adalats and other measures also, including judicial settlements, where the judges think that in a particular case can be settled by them, they can. That is also provided in Section 89. And therefore, another thing which COVID brought, if I may say so here, this has changed the methodology by which the system has to work. Court now, as I said earlier, is not only online, which were there. Even today, they are in a hybrid mode. Many courts are, because COVID that still persists. And there is a talk because of technology that even in future, even when we go back to old normal, but this hybrid system should continue because of its various advantages. Then there is another thing which is happening, and which has, certain countries it is already experimented, and in India also there has been a talk about that. That is ODR, online dispute resolution. That where the portal or platforms which are private in nature and can settle some kinds of disputes. Then this is a successful experience in, say, Dubai, Hong Kong, Italy, and some of other European countries, and including in some states in America. So we are now trying this to be experimented. And another development which has taken place when we talk of dispute resolution mechanism is that self-regulatory mechanism which is coming, particularly this consumer disputes and OTT disputes, etc., where self-regulation is coming. So therefore, this is today the landscape insofar as dispute resolution mechanism is concerned. So what it comes now, and when it comes to education, so it automatically calls for and justifies continuing legal education, not only for judges, but for lawyers as well, for two reasons. Number one, the new areas of laws which are coming, that judges have to get themselves accustomed or conversant with these laws. Likewise, lawyers should. But then many new methods which are being developed, that also calls for that there has to be judicial education, there has to be education for lawyers. And this again, in my preliminary comments, I will say that it has to be both. At first, the curriculum and Professor Rajkumar is doing excellent work in that, and for this reason, his law school today is number 1 in the country and number 70 in the world. And in 12 years, such an achievement is unparalleled. And it is because of the reason that he is keeping pace with the changes which are happening and which I have narrated in brief. So therefore, on the one hand, there has to be change in curriculum. There have to be new courses. Existing courses have to undergo change for students. And likewise, there has to be, if we passed, a particular lawyer passed out 20 years ago, 15 years ago, and not conversant with these issues, then for them also continuing education is required. And for judges, as Professor Rajkumar said, because it is ultimately they, if the cases land up in the court, they have to deal with these matters. So therefore, would be my comments.
Thank you for sharing in detail your view and explaining it along with facts and figures. I'll go to Justice Michael Winsel now, who will give us his perspective, what is happening in the United States as far as continuing legal education is concerned. Is law able to keep pace with the kind of cases that they are seeing? All of that. Over to Justice Winsel.
Well, let me say aloha, Tarun. I'm so glad to be back on your show. It's a privilege, and to be with my two colleagues, Justice Edens and Justice McKenna. But I, in large part, am very excited about seeing Justice Sikri again, who is one of the heroes, I think, of the three of us, who has been a representative of India in Hawaii, and has helped us with judicial education, which I'll refer to in a moment. The kind of difficulties that judges are facing today does, to a certain extent, dictate the importance of education and the type of education we'd have, and also the nature of issues that are repetitive, or the nature of issues that cause high volumes of cases can lend themselves to a kind of alternative dispute resolution, such as arbitration and mediation. But with that said, let's think about the issues that judges have to face. The most important issue that is often, I think, said by judges who are participating globally in a lot of the pressing issues of the day has to do with the environment, because obviously this is an international issue. And the existential threat, very fundamental threat of climate change, is something that looms all through the world. So to be able to adequately equip the men and women who are judges on this very important issue, there has been a lot of international collaboration in terms of education that Justice Sikri has been central to, as well as Dean Kumar, Vice Chancellor Kumar, so much so that Justice Sikri, as well as Vice Chancellor Kumar, have traveled to our state, Hawaii, to assist us in, among other things, developing a curriculum for our environmental court that we have. There are only 2 environmental courts in the United States, and ours is the only one of general jurisdiction that includes civil and criminal cases. Well, in addition to that, because of the severity of these legal issues, an organization has arisen under the United Nations that is called the Global Judicial Institute on the Environment. This was created approximately 7 years ago. And the reason is so that judges can try to equip one another and support each other on the issue of climate change, which is a good kind of model to think about in terms of judicial education, because you have some issues that are quite legal and maybe historical, constitutional issues, for example, human rights, that many judges have probably been trained on. But as Justice Sikri said, you have new issues. And if you consider an issue such as drones and privacy, issues such as increasing greenhouse gas emissions and the threat to society, or the threat to the rights of citizens to a clean and healthy environment. That's contemporary, that's new, and that involves a lot of new technology. So as the our great Vice Chancellor has said, that means that judges need help. And you often need to call out for experts who can, in an organized way, through training that is also somewhat formalized, such as a Global Judicial Institute or judicial conferences, have education. We are evolving in our society in a way that Justice Sakri mentioned. There's more and more inequity in many ways. This kind of separation of wealth, the wealthy from the poor is getting greater. And to some extent, that means that there can be more litigation. Unfortunately, I think I would submit that this is something that is recognized now by law professors in the area of the relevance of the laws throughout the world. We're having less access to justice. It's becoming more expensive. Attorneys are difficult to find in terms of a affordable rate oftentimes. So that would mean that perhaps mediation is helpful so that decisions can be made in a way that's less expensive. But the difficulty is, in terms of, I would say, international trend, you have a whole group of citizens, consumers, who are being moved out of the court system. They don't have access to the courts because of contracts. If you want a phone, you often will sign a contract that says you have mandatory arbitration. So if you have a claim of fraud against the phone company, or this can happen with organizations that are corporations that provide services for consumers, such as even medical care, to be a member of a medical unit, a medical company that provides care. Sometimes it's necessary to sign a document that says that you aren't going to go to court. You'll have an arbitration. And those arbitrations tend to be imbalanced oftentimes because there's not real parity between the parties. You have a phone company versus an individual citizen. So that's an unfortunate trend. But the kind of cases where you have parity, in other words, you have a sort of an equivalence of wealth or an equivalence of influence on both sides of the case, you could have the good fortune of having an individual such as Justice Sakri, who is an eminent retired member of one of the most respected courts in the world, the Supreme Court of India. And so that's great. That can be a very helpful, well-informed, orderly proceeding that is an alternative to a normal legal system. But I think overall, we do have a danger facing us that the average citizen is losing access to courts, particularly in the United States. In the United States, if you are accused of a crime, then you have to go to court, of course. And in terms of the phenomenon of the number of cases, the United States versus India has a very interesting kind of difference. We incarcerate about 700 people per 100,000 in the United States. India's incarceration rate is something like 30 or 40. So you don't have the level of inappropriate and exaggerated incarceration in India that you have in the United States. So the training of judges should have a lot to do with criminal cases in the United States, because we have so many citizens that we're putting in jail and legal proceedings that accompany that. So I would submit that really it's important to have better training of judges so they understand the kind of sentencing that could involve treatment and rehabilitation, so we don't continue this cycle of over-incarceration that we have in the United States. In Hawaii, we incarcerate about 400 people per 100,000. So we incarcerate in terms of per capita at a rate that I think is greater than Russia, for example. So India may not have the same needs for judicial education of judges, because I'm not sure you have quite the press of criminal cases that we have. But I did want to mention that because it's really unfortunate that judges don't get more training in this important area of the criminal law with respect to sentencing. So Tarun, thank you for letting me give you a long answer, and I'll pass to my colleagues.
Justice Wilson, thank you for giving us a very holistic example, starting from drones and technology to environment to judicial training of judges. With this, we would like to come to the end of part 1 of our series on dispute resolution practice and continuing legal education for judges. In part 2, we'll have the pleasure of hearing Justice Sabrina McKenna and also Justice Todd Edens, who will share their views. But that's it for now. Thank you so much for joining, and thank you, viewers, for tuning in. We will see you in part 2. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.